Breaking news out of Chicago, Illinois. The Seventh Circuit Court of Appeals today has received the reply papers from the plaintiffs, the National Association for Gun Rights, and Mr. Bevis in the Naperville case dealing with the Illinois quote-unquote assault weapon ban and magazine ban. Let's talk about this brief when we get back. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. If you haven't picked up a copy, you can also get an audiobook, by the way, and paperback. Check it out. I think you'll learn a lot. If you're an American gun owner, a lot of lessons to be learned there from the mistakes the Ukrainians made that we can learn, so why we should never give up our right to keep and bear arms here in America. Okay, folks. Major brief submitted. I'm going to put a link to it down below today. An excellent brief has been filed in the Seventh Circuit Court of Appeals by our home team, the Second Amendment supporters, the National Association for Gun Rights, and Robert Bevis. The attorneys in the case are Barry Arrington and Jason Craddock. We've talked about them before in their work before. They do great work, and they're out there fighting for our rights at the Seventh Circuit Court of Appeals. They submitted their reply brief. It was very focused on a few arguments that the anti-gun state of Illinois was making. I'm going to cover some of the big points here, a few observations, a few points of clarification, but overall I think it was a strong brief, and I'll link to it down below. To begin with, of course, the National Association for Gun Rights starts off with an excellent point, the obvious point that says, quote, "This is a simple case. Tens of millions of firearms and magazines of the type banned by the state of Illinois are possessed by law-abiding Americans for a variety of lawful purposes. The Second Amendment protects carrying weapons that are in common use," and it goes on from there. The bottom line is this is absolutely the case. We know from Caetano in 2016 that the fact that 200,000 stun guns being invented, by the way, in the 1970s, are considered in common use and protected under the Second Amendment. And this is the point, of course, that the lawyers make here in our favor right off the bat. They go on to say, of course, specifically that the banned semi-automatic rifles in Illinois are the second most popular firearm in the United States, behind only semi-automatic handguns. And of course, they make a reference to the fact that they've already submitted material, so they're not going to repeat themselves, which of course is the purpose of the reply brief. Just to remind you, for those legal geeks out there, the plaintiffs, the Second Amendment plaintiffs, filed their motion in the Seventh Circuit Court of Appeals seeking a preliminary injunction of the Illinois bans. They were denied, and an expedited hearing was set. The state of Illinois filed their opposition papers, and now the plaintiffs, the Second Amendment plaintiffs, have filed a reply. At this point, the next major thing to be looking for is, I believe, the lawyers in the Barnett versus Rowell case, which is that consolidated case that's coming out of the Southern District of Illinois, is going to be filed, I think, in the next couple weeks. And then there's an oral argument set, which I think all the cases have been consolidated. For this case, specifically the assault weapon ban and the magazine bans, all of this has been consolidated, so it's all going to be heard at a single day in the last week of June, I believe, and it's all going to be argued, meaning this case here of Bevis will be argued alongside the Barnett case. The Bevis case came out of the Chicago, Illinois, Northern District of Illinois, where the Second Amendment plaintiffs lost in the district court, and the also case that's a sister case coming out of the Southern District of Illinois Federal Court in front of Judge Stephen McGlynn, where the Second Amendment plaintiffs won that case, got an injunction. And those cases, both the one out of the Northern District where we lost down below, the Southern District where we won down below, those are being consolidated and heard by the Seventh Circuit Court of Appeal at the end of June. As you know, the Supreme Court has paid attention to this case because Justice Amy Coney Barrett demanded briefing from the state and received it. And after the Seventh Circuit Court of Appeals raced ahead and scheduled this emergency fast hearing, the U.S. Supreme Court basically patted them on the head and said, "On your way," for the moment. But certainly it is pretty clear the Supreme Court is watching this case by virtue of what they've said by requesting the briefs from the state of Illinois. Nevertheless, it looks like the Seventh Circuit is moving with speed, and that is what we want to see. And in light of that, I'm going to carry on with what this reply brief says in support of our rights by the National Association for Gun Rights. It goes on to say that the banned firearms are obviously arms. Quotes the Supreme Court in saying, quote, "The Second Amendment extends prima facie to all instruments that constitute bearable arms." That's very important. If something can be a bearable arm, meaning it can be carried, it's prima facie considered protected by the Second Amendment. And then, of course, this This brief goes on to draw a distinction, tries to point out, which I've talked about on this channel before, the games that the anti-gunners try to play. They point out that all you need to do at the textual level of Supreme Court analysis or Second Amendment analysis is say that a bearable arm has somehow been infringed upon. Once that's the case, then of course you immediately get into the in common use test, which arises from the historical analysis that was performed by Heller. Just to jog your memory, the Heller case by the Supreme Court in 2008 conducted a text and history analysis approach and came up with the in common use test that simply says that if a modern firearm or if a modern arm is in common use today by Americans for lawful purposes, it cannot be banned. It's protected by the Second Amendment, period, full stop. What Heller did is, again, that text and history analysis that gave rise to the in common use test. There is no justification for courts such as the Seventh Circuit Court of Appeals here to redo the Heller test because the Supreme Court has already done that test and given the answers to the lower courts, also known as inferior courts under Article 3 of the United States Constitution. So the only thing that needs to apply here, because it's very obvious, it's judicial notice, it's a no-brainer, no one can possibly dispute it, that these semi-automatic firearms, semi-automatic rifles are in common use by millions of Americans, and magazines that hold more than 10 rounds are in common use by tens of millions of Americans. Everyone has these things. So there's really no dispute that these things are in common use for lawful purposes. So one of the things that the National Association for Gun Rights does in this brief is they point out what I've talked about repeatedly on this channel is the little game that the state of Illinois and all the anti-gun community is trying to perform, which is to say the question is not, is an arm in common use for lawful purposes by Americans? The question is, are these arms used frequently for the purposes of self-defense? So they're trying to create this impression that in court, the Second Amendment plaintiffs have to show that these firearms are frequently used for self-defense. But of course, that is not the standard because you just have to look at two cases. You look at the Heller case in 2008 that specifically talks about just we don't know why Americans choose handguns for self-defense, but they do. They're the quintessential weapons, and therefore they're protected because they're in common use. There was no analysis of how many percentage of Americans own them, how many Americans own them, how many guns are, none of that stuff. There was no need for that. There was no discussion of how many times handguns were used in self-defense. There was no discussion in Heller of how many times people pulled a trigger in self-defense using handguns. None of this analysis was done, and yet the U.S. Supreme Court in Heller came out and says, obviously handguns are protected arms because they're in common use by Americans for lawful purposes, period, full stop. You don't need to go for any beyond that. By the way, I want to be clear because a lot of you missed this point. If an arm is in common use by Americans for lawful purposes, it is protected, period, full stop. We win. I repeat, we win. We win. We win. Now, some of you like to criticize me and say the in common use test is a problem because it doesn't protect all guns, perhaps new guns or newfangled weapons or something like that. That is not the case. Let me be clear. If an arm is in common use for lawful purposes by Americans, which just means possession, by the way, because Heller just talks about possession of handguns, Caetano just talks about possession of stun guns. Again, in Caetano in 2016, there's no discussion about how many times people use stun guns or tasers in self-defense. None of that discussion. All it is Justice Alito says in his concurrence in Caetano in 2016 that 200,000 stun guns invented in the 1970s, proving that modern arms are protected under the Second Amendment. 200,000 was enough. No discussion of self-defense acts or anything in Heller or in Caetano. It's just about, are these things commonly owned by Americans for lawful purposes? That's it. That's all that matters. But keep in mind that what they don't say is the only way an arm can be protected is if it's in common use. If it's in common use, it's protected. You don't have to do anything else. In a hypothetical scenario that we may have to confront down the road at some point, it may be the case that there's some brand new weapon or something that comes online that's not yet in common use. They try to ban, and if that occurs, the in common use test is not the only way to win. I repeat, the in common use test, if we satisfy it, we win, period, full stop. However, there are other ways for arms to be protected under the Second Amendment, but we don't need to get into that and complicate things when we're dealing with easy layup cases, which a semi-automatic rifle ban is an easy layup case. Because semi-automatic handguns are protected arms in Heller. Keep in mind, and by the way, the lawyers here in the National Association for Gun Rights brief did a very good job of this. Keep this critical fact in mind. The Heller case was decided in 2008, right? And said that handguns, modern handguns, are protected arms under the Second Amendment, cannot be banned. What happened in the year of our Lord, 2007, 12 months before the Heller decision? The answer was there was a mass shooting at Virginia Tech by a guy who used semi-automatic handguns to shoot 32 people less than a year before Heller. Semi-automatic handguns are protected arms, and of course we know in Caetanos, Justice Alito's concurrency specifically references modern semi-automatic handguns being protected. This is extremely important, not just because of if you protect semi-automatic handguns, the preferred choice of criminals if you want to go down that path, you obviously are going to protect by the principles of a fortiori ori, if it's true for the lesser, it's true for the greater, semi-automatic rifles that commit, are involved in far fewer homicides and criminal acts than handguns ever have been. Beyond that, keep in mind what is an essential component, and this is the other major part of this brief here by the National Association for Gun Rights, which is a good brief. You should check it out. The other critical component or essential component of a modern semi-automatic handgun or a modern semi-automatic long gun rifle is what? A magazine. Now maybe they're detachable. Usually they're detachable. Sometimes they're fixed. But either way, a magazine is an essential component. So one of the critical things here that the lawyers for the Second Amendment are arguing is that magazines are also protected arms. And they do a very powerful job of this. And they make three good points. The first point, of course, is that the right to keep and bear arms implies a corresponding right for the items necessary to make the right effective. What's interesting is in this case, they do an excellent job of quoting the Ezell versus City of Chicago case from 2011, talking about how the Second Amendment recognizes the right to train, if you want to train, to become proficient. Now, that's particularly important because who is the court we're in front of today? Who is the court that the Second Amendment people are in front of today? The answer is the Seventh Circuit Court of Appeals. So citing to the Ezell case from the exact same court, the Seventh Circuit Court of Appeals in 2011, for this proposition that things that are implied by the Second Amendment are also protected is a very good strategic move because the Seventh Circuit has already decided it, and putting that case in front of the Seventh Circuit Court of Appeals to remind them what they've decided in the past is always a good strategic tactic. Good move here by the lawyers for the Second Amendment. Then they go on to talk about how obviously ammunition would be necessary for the firing of a firearm, and if ammunition is protected, obviously we know barrels would be protected, so are magazines, because if you don't have magazines in a modern firearm, then at best you have a single-shot firearm, and many firearms, actually you can't fire a single round if you don't have a magazine in it, so in some ways you make certain guns inoperable and other guns a single-shot revolver, or single-shot pistol, I should say, if you don't have a magazine. And this is an excellent argument and clearly the correct one. Beyond that, I should note they did an excellent job here, National Association for Gun Rights and the lawyers for them, in quoting Justice Thomas, who makes reference to that Ezell case, when he goes on to say that a constitutional right implicitly protects those closely related items necessary for their exercise. And I think that is clearly the case, and we've discussed that. And last but not least, the Bruin case makes an excellent point in terms of protecting things like barrels, magazines, triggers, things that are essential or necessary for the purposes of firing. And I would argue this also would include silencers or suppressors. This is the language that these lawyers cite from Bruin. I think it's a good move that they did so. They point out that, quote, in Bruin, the Supreme Court held that the Second Amendment's definition of arms covers all, quote, instruments that facilitate armed self-defense, period, close quote. Did you hear what I just said? That's not Mark Smith. That's not the Four Boxes Diner. That's not even the lawyers for the National Association for Gun Rights. It's the United States Supreme Court in Bruin. They say that arms includes, quote, instruments that facilitate armed self-defense. Do magazines facilitate armed self-defense? Obviously, the answer is yes. There's no debate about that. And I think this is all judicial notice. This is a no-brainer. I want to talk about the text of the Second Amendment, and then I want to compare that to the history. This is very important. As you know, the way it works now is you start with the text of the Second Amendment. That's always the way you work with constitutional law. You look at the text of the Constitution and see what the text says. It's no different than when you start with a contract dispute. Look at what the contract says in writing. So if you look at the text of the Second Amendment, it says the right of the people to keep and bear arms shall not be infringed. Now, that's what the words say. But what do they mean? Well, we don't have to make it up. Courts like the Seventh Circuit Court of Appeals don't get to make it up on the fly. Why not? Because the Superior Court, the Supreme Court itself, has defined all the key words of the Second Amendment. It's defined the right to keep as the right to possess, the right to bear as the right to carry outside the home for self-defense, among other things. Arms, anything that can facilitate armed self-defense or something that can be used offensively or defensively, including, by the way, body armor, according to Samuel Johnson, the 18th century lexicographer from England. So all these things have been defined by the Supreme Court. So the way you do textual analysis is really 3 steps. This is very important, especially for you legal eagles, geeky people out there. The textual analysis has really three concentric circles that capture rights, that capture activities that fall within the Second Amendment, the way to think about it. First of all, you start with the text of the Second Amendment itself. Then you add on the text of the Second Amendment as defined by the U.S. Supreme Court. So all the terms and definitions of the Supreme Court set forth in Heller, Bruin, Catano, whatever, that includes certain things, like the right to carry firearms outside the home for self-defense in Bruin. So you got the text of the Second Amendment plus what the Supreme Court defines the text as being, and last but not least is anything that's necessarily implicated by the text as interpreted by the Supreme Court, as well as anything that facilitates armed self-defense. So you see what I just did there? There's really three, maybe even four components that make the scope of the textual right to keep and bear arms very, very broad, very, very big. If you think about it as a big circle of what goes in there, you start with the text, goes in the pot. Then you add those terms defined by the Supreme Court. It makes the pot bigger, encompasses more things. Then it involves anything that's necessarily implicated by that, very basic constitutional law, right? For example, in the First Amendment, it says you have the right to free speech, the right to the free press, but that doesn't talk about the right to buy ink. It doesn't talk about the right to buy pens and paper. It doesn't talk about the right to buy a printing press. It doesn't talk about any of these other things. And yet those things are implied within the right to keep, the right to a free press and the right to free speech. So too with the Second Amendment, the right to keep and bear arms includes these other things. So you have the text, plus what the Supreme Court has said, plus what are necessarily implicated by the text as interpreted by the Supreme Court. And last but not least, you have the language from Bruin that says that arms includes anything that facilitates armed self-defense. So all that stuff goes into the pot of what falls within the definitions of the Second Amendment. And once an item or an object or some sort of conduct or anticipated conduct falls within that big circle of stuff, of rights that we have, once that falls in there, it triggers a critical moment in time. It sends the burden of proof to justify a modern-day gun control law over to the government. And by analogy, think about it, once the burden shifts to the government, it's no different than when the government goes into a criminal court trying to put you in jail for a crime. The burden of proof is on the government. The presumption of innocence is on you, have the presumption of innocence. So too in the context of the Second Amendment, when a Second Amendment right is implicated by the text of what I just said, guess what happens? The burden shifts to the government, and the government has the burden to show that the modern-day gun control is constitutional, and when in doubt, a court should throw it out. So again, once the text is implicated, the burden shifts to the government has to show that those modern-day gun control laws are constitutional. If there's any doubt, they lose. When in doubt, you throw it out. Now, here in the context of a gun ban case or a arm ban case, once the text is implicated, which is very easy here because, again, semi-automatic rifles are clearly arms, and magazines that go within that can be used offensively or defensively. They help facilitate self-defense. They also, of course, are an essential component of a modern firearm, which we know are protected. All modern firearms are protected arms presumptively. So all that falls within the text. Now, in the context of an arms ban case, though, the burden shifts to the government. And what does the government have to show? The government has to, before they even have a chance to justify their ban, they must show that the arms are not in common use. They must show that Americans do not commonly, these arms are not in common use by Americans for lawful purposes. It is simply impossible. Simply impossible. It'd be literally being given the burden to show that water is not wet. Because keep in mind that every single day you open up another anti-gun propaganda piece from some state governor or from some anti-gun group. What are they all complaining about? There's too many guns in America. There's too many quote-unquote assault weapons in America. There's too many assault rifles in America. There's too many of these scary large-capacity magazines. They're making the case for us. Do you see what happens there? The fact is that the anti-gun community and the anti-gun governors, the anti-gun politicians are saying there's too many guns, too many assault rifles, too many magazines that hold more than 10 rounds. They're admitting that these items are in common use by Americans for lawful purposes. They're admitting the case. That is why, really, at the end of the day, just like the National Association for Gun Rights said at the start of this brief, which I'll put a link to down below again, when it says this is an easy case, it really is. Because there is no argument that the government can come up with that these are not in common use. And once they cannot show that these rifles and these magazines are not in common use, it's over. We win. We don't have to go crazy. We don't have to go beyond that. We win. Now, I should just say one other point. I do think that the that the lawyers did a good job. They do argue in the alternative. They do talk about historical analogs. They said, look, we don't need to do this, but we're going to do it anyway. That is always a good move. If you're a litigator, you always want to argue in the alternative. It's almost like your job. Even if there's stuff that you think is irrelevant, you still have to argue it just to be safe. And I think they did a nice job. This, for example, one of the nice things I think they did is they point out that the state of Illinois is arguing that, you don't need these semi-automatic rifles because there's alternative means of self-defense, such as handguns. But as you know from Heller, that argument was specifically rejected by Heller, that says the mere fact that, in D.C. at least, back in Heller, the mere fact that some people were allowed to use long guns or rifles for self-defense or shotguns for self-defense was not a basis to justify the ban on handguns in Heller. And isn't it and I'll just leave with this, isn't it kind of ironic that back in 2008, the anti-gun movement was all about banning handguns and justifying the handgun ban in Heller? They said long guns are good, handguns are bad. And now in the year of our Lord 2023, we find ourselves in the reverse situation where the anti-gunners are like, look, you've got handguns. Why do you need these semi-automatic rifles? Why do you need these AR-15s? You've got handguns. Isn't it funny how it flips? The reality is that they want you disarmed. They want us all completely disarmed and all firearm ownership to be banned. They only want a monopoly on guns in the part of the government. They don't want any of us to have guns. They do not want the Second Amendment to exist. They're very upset about this, but we're smarter than they are, and we know we've got truth on our side, which is the text of the Constitution and our history that says we as Americans get various things, including but not limited to the right to keep and bear arms. Okay, folks, hope you learned a little bit something here today. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.